This way. The Colorado Court of Appeals is now in session. Good morning, you may be seated. Let's see. Great, good morning, everyone. My name is Judge Pawar. To my right is Judge Johnson, and to my left is Judge Richmond. We are hearing one case on this morning's setting, and that case is Sherman versus Brannon Sand and Gravel, case number 23CA1266. Before we get started, just a brief overview. I know counsel are experienced, so I'll just do this quickly. We are being recorded and we are being live streamed, and so if there's any information that is private or confidential that you do not want disseminated, please be mindful not to reveal that information because it will be recorded. We will not be able to redact it later. Each side will have 15 minutes. Counsel for appellant, if you would like to save some time for rebuttal, that's on you to keep an eye on the timer. We'll do our best to endeavor, but like I said, it's up to you to sort of stop your argument and manage your time. There's a toggle switch on the lower right lip of the podium if you need to raise or lower the podium. Try to stay behind the podium. Make sure that your voice is being picked up by the microphone so that the recording will be we'll have a good recording. Let's see. I don't think there's anything else. Do I have any questions from either counsel? Okay. Great. Well, when you're ready to proceed, you may. Thank you.
Good morning. I am Brent Johnson of Fairfield and Woods on behalf of the appellants, collectively Brannon. In March of this year, the U.S. Supreme Court heard oral argument in the mifepristone case, and there were many questions about standing. One justice asked about the proportionality of a group of doctors seeking standing on grounds of conscience versus the impact of potentially restricting availability of that drug nationwide to millions of women. I was struck by that question about proportionality because I think that that is the court looking at the big picture of the case. And I would like to, this morning, take a look at the big picture of two key issues in this case, the first of which is standing. The 8 plaintiffs in this case all live at least 1,136 feet from the nearest boundary of Brannon's SIP use area, nearly a quarter mile. The sole injury that they claim is the visual impact from stockpiles of materials on the site. At that distance, a 25-foot tall pile of materials only occupies 1.25 degrees of view. And to put that into perspective, when I hold my index finger out at arm's length from my eyes, the height of my finger occupies slightly more than 1.25 degrees of angle of view. That's the injury that they are claiming, the visibility of stockpiles that could be covered up by a finger.
So counsel, please. Thank you. Before we moved a little too far past, when you said, you're talking about the distance they live from what you said was from the SIP area. Now, when I read the section of the resolution, the zoning resolution, section 3602, it talks about 3 different kind of categories of people that have standing to appeal the BOA order. The applicant, would have been the concrete company, and a budding property owner, or a person with an interest in real estate located within 1,000 feet of the subject property. So I'm interested in that middle category, and a budding property owner. Is that different than the third category?
Well, I think any abutting property owner would have standing under that. The third category extends it farther than that to up to 1,000 feet if certain conditions are met.
And we so some of the some of the neighborhood residents have standing under the abutting property owner.
No, Your Honor, because those distances, abutting or 1,000 feet, the most important language there is from the subject property, and what is the subject property? And that was discussed in the staff report and at the hearing, and Planning Services presented two options for standing. What is the subject property? Is it the entirety of the legal boundaries of the two parcels that Brandon owned, or is it just the boundary of the SIP use area, the area within those two parcels, in the center of them, that is being asked for approval for this use plan? And so,
Well, an abutting property owner, it would not be possible to abut the SIP.
well, the SIP in this case extends to the property boundaries on the east and west sides, I believe. So, sure, in many cases it could be. In this case, plaintiffs to the north certainly do not abut the SIP use area.
Well, then wouldn't it be, I mean, wouldn't the applicant, in this instance, the concrete company, be able to just circumvent this abutting property owner by always having a border or a barrier, a buffer between the SIP area and the outermost property limit?
I don't think there's any evidence of any kind of circumvention of that sort in this case, Your Honor.
True, but I guess I'm just trying to understand, why would we have two different categories? Why would we have an abutting property owner or a person? And why wouldn't those always be the same?
No, the abutting property owner automatically has standing. The language of the section that Your Honor referred to gives standing to people who are not abutting but are within 1,000 feet only if they can demonstrate certain categories of harm. So abutting is automatic. Within 1,000 feet, you have to demonstrate certain categories of harm.
But I think what Judge Proar is getting to is, if you read the plain languages of the statute, there is, or the regulation, there's the applicant. Nobody here is disputing that. There is no or then between an abutting property. And then there's an or after that to then say, so I don't see or modify.
Judge Johnson, I'm sorry to interrupt. Bailiff, the clock seemed to have been stopped, and I wanted to just, before you continue. Sorry to interrupt you.
Sorry.
I don't see subject property for abutting property to be actually probably part of the 1,000 feet requirements. So, or of the SIP revision area. I mean, I assume it has to be abutting, and that makes sense, but to the subject property. But I don't think subject property is just the SIP revision area.
Well, Your Honor, that's the question, and that question was posed to the BOA at the hearing, and the Planning Services and the staff report presented those two alternatives. This had maybe never come up before, where there was an SIP area that was smaller than the legal boundaries of the entire parcels. And the Planning Services and the staff report said if the subject area under that section is defined as the SIP area, none of these plaintiffs have standing. They're all beyond 1,000 feet.
Well, again, I mean, the abutting property owner is not qualified by abutting the subject property, even if you were to interpret subject property as the SIP only. I mean, wouldn't it say an applicant, a property owner whose interest abuts the subject property, so that there was continuity?
I think that abutting or 1,000 feet both must refer to the subject property. Abutting to what? The subject property. The only thing that's left in the statute in words is subject property.
But wouldn't the applicant then it would read, an applicant with an interest in real property located within 1,000 feet? If we were to read this and make it harmonious with each provision, that subject property, an applicant who is within 1,000 feet of the subject property?
No, the applicant is Brannon, who is applying for the SIP.
I understand that, but you're trying to read in an abutting property owner based on the subject property, whereas I think Judge Boer is saying that isn't part of that requirement.
I think the only way that makes sense at all in terms of both abutting property or within 1,000 feet is to say abutting to what or within 1,000 feet to what. And the only thing that is left in that regulation is the subject property. And so the question is, what is the subject property?
Right. I understand your reading, counsel. I understand, and I understand my questions and how you've answered. I appreciate that. I don't want to take up too much of all of your time on this one aspect. My next question is, if we were to disagree with that and say, okay, we have a difference of opinion about the how to read that middle section, abutting property owner, would we need to decide what subject property means if there was also a common law standing for the property owners who are not abutting?
Well, if you disagreed with me and said that the subject property is the entire legal boundary, then some of these plaintiffs, at least some of them, are abutting and would have standing under that regulation.
And as to the remainders, would we be able to then, we would have to consider under common law whether there was standing?
Or under that 1,000 feet provision, yes.
Thank you.
Yes.
You understand the word property in the phrase abutting property owner to be exactly the same as the meaning of the phrase subject property in the next clause, correct? That's your position?
Well, I don't think so, Your Honor, because subject property is the property that is the subject of the matter before the Planning Services
Okay,
Department.
in this case, the SIP or whatever it's called.
Yes, the SIP use area, the 17 acres, not the entire 32 acres.
Okay, and the abutting property is the property, all the property owned by Brannon, is it not?
Well, the abutting property would be property owned by other owners. Brannon is the applicant. So other owners who have property abutting the SIP use area would have
But
standing.
not abutting the borders of Brannon's, the outer borders of Brannon's property. That's
Correct, if it's not abutting to the SIP use area. In this case, this property has been zoned industrial since 1981. The concrete batch plant has been there since that date. The concrete recycling has operated since 2014. 25-foot high piles were approved in 2018. So the harm that the plaintiffs are claiming is to see the concrete material piles that have been there, plaintiffs admit, for 4 or 5 years. There's no new injury from the 2022 approval of this. This is not a case like all of the standing cases cited by plaintiff, where most of them are zoning cases where there is an important adverse zoning action about to be taken or some other material adverse action that's about to be taken. Here, it's just being able to continue to see things in the distance that occupy that amount of space. And I don't think that qualifies as injury in fact. That's just incidental, not direct and palpable as case law requires.
Well, go ahead. Let's assume it is an injury in fact, because we have to take the plaintiff's allegations as true. Isn't it also true that the new SIP revision is much bigger? So now we're also dealing with even more concrete that unless there's a proper border, it would be pretty unsightly.
The revision expanded the area within which material stockpiles could be located from, I think, 100,000 feet roughly to 160,000 square feet, which is 4 acres within the SIP use area. And there was evidence in the record, and we cited it in our brief, that doesn't necessarily mean expanded use. It allows for more room for trucks to maneuver and equipment to maneuver. And in some cases, it might allow for the stockpiles to be lower than 25 feet. But there was no evidence in the record whatsoever that change would change the visibility of this area. And in any event, it would still be much more than 1,136 feet from the plaintiff's residences.
Counsel, you have a couple minutes left, and so I have a question. I'd like you to address the southern border, Airport Road, and I understand that the SIP didn't propose any landscaping or fencing along that southern border. Please address that, and what, if anything, relevance does it have for us?
The staff report addresses that, and I would encourage the court to look at 3 pages in particular in the staff report, and those are at court file 21. The staff report itself starts at court file 2179. There are 3 pages in it that address the screening. And as to Airport Road, what the staff report says is that much of the view is blocked by the concrete batch plant itself, a very tall structure, and that it's more than 700 feet below the SIP area, and that plaintiffs hadn't shown any evidence that the stockpiles would be visible from that location.
And so your position is that the batch plant is the barrier?
In large part, yes. I will save my remaining time for rebuttal if I may.
Thank you, counsel. Sucks. Do you need a new one? No, thank you. When you're ready, thank you.
Good morning, and may it please the court. My name is James Silvestro. I'm with the law firm of Ireland Stapleton, registration number 43982. I'm here today on behalf of 8 neighbors of Brannon's property to ask this court to affirm the district court's finding that Douglas County abused discretion and exceeded its lawful authority by ignoring its screening requirements under the Douglas County zoning resolution. I want to start with the standing issue, which the appellants have raised first. And before I get to the specific DCZR standing requirements under the county code, I do think it's really important not to lose sight of the common law standing principles at issue here. That's important because Brannon actually hasn't cited to any authority that would suggest that a county, acting of its own volition, could artificially narrow the scope of standing under Rule 106 for a land use appeal. The common law principles of standing in Colorado provide that standing is a relatively easy test to satisfy. They also provide
Counsel,
yes, please.
How would you respond to your opposing counsel's view that the injury, let's assume there was an injury, in fact, of there being unsightly concrete stockpiles. What do you do with the fact that that has visually been there since 2018? How is that a new injury, in fact, based upon the SIP revision?
And so I think that really goes to the questions that were being asked about the scope of the 2022 SIP revision. And there are 3 principal differences between what was approved in 2018 and what was just approved in 2020, which is what we're here to talk about today. In 2022, the concrete stockpiling area, which is the issue for the screening, was expanded by 50,000 square feet. I think council said it's going to be 4 acres of new waste concrete that will be stored at the site, up to 25 feet. Now, they argue that that allows them more ability to maneuver, and maybe that won't create the same screening issues, but the reality is what we have to look at is what was approved. The SIP revision allows them to expand that by nearly 50%. The second issue, which the district court, Judge Holmes, really keyed in on, is the fact that it allows them to store 25-foot stockpiles in different areas. So the question about whether or not this material is screened is materially different in 2022 because you have to look at where the configuration of those stockpiles in a larger area is going to be.
So that's a good question, and I think this is what your opposing counsel was talking about, like proportionality. If they're 25-foot stockpiles and they were screened, and they could just be stored in a wider area, a broader area, let me call it that. Well, why does that affect the screening? I mean, if the screening has been sufficient, then why is it a new injury? In fact, I guess is still the same question.
Because it's more volume of material, so there are going to be different angles where you can see that.
Okay, so not volume height-wise, but there'll be more of them?
There will be more 25-foot pile stockpiles, an extra 4 acres of that, and it's also reconfigured around the site. If you look at the 2018 approved site improvement plan and you look at the 2020 site improvement revision that we're talking about today, where they are planning to store these materials is materially different. And then I also want to get to the third issue, which is different, which is that in 2018, they had proposed some landscaping, but the primary method of screening in 2018 was an earthen berm that would raise those trees up higher so that they would actually screen 25-foot tall stockpiles.
And that would be on the inside of their property line or
Correct.
outside of the SIP area?
No, it was part of the SIP area.
Part of the
but
SIP
the
area.
reality is that in 2022, they completely got rid of that earthen berm proposal because they never actually built out what was approved in 2018. And so
Oh, go ahead.
I was just going to say, if you look at what the county memo talking about the history of this property is, it's cited in the record, they actually say the 2018 approval has essentially been abandoned because Brandon never built it out. They had to stop their crushing operation because they never actually complied with the requirements of the 2018 approval. That's what necessitated this new land use application in 2022. Under the Douglas County zoning resolution, a revision is much more substantial than an administrative modification. A revision, which is what they sought, is an approval for an entirely new site improvement plan. And so there was no waiver relative to 2018 because what we were looking at is a new land use approval that the neighbors timely challenged in 2022.
Can I just clarify for you, Judge Pawar's question on the 25-foot? The point the plaintiffs are trying to make is that even though the company may right now say that the broader area might make the stacks lower, because the revision would technically allow that whole area to be 25 feet, it might change the visibility. Is that correct?
Yeah, so
Okay.
to get a site improvement plan or a site improvement plan revision, the Douglas County Code says it's the same process. Every element of what you're proposing to do has to comply with all of the land use rules in Douglas County. And the one we're talking about today, the one that's relevant to this application, is section 1416, the screening rules. And so if what they're asking to do is 160,000 square feet of 25-foot tall stockpiles, Douglas County was required to consider whether or not what they were proposing would comply with 1416. And the record is essentially undisputed. There are numerous areas around the site in public rights-of-way, in adjacent areas along Airport Road, as Judge Poir noted, where there are photos showing that there's no screening whatsoever, even after the landscaping was installed. And I think
Well, counsel, I read the record as saying that the screening was not a solid wall, but that the vegetation and the trees were provided sufficient buffering around the north and east and west. And so that's why I'm focusing my question on Airport Road.
Right. Well, so I think Airport Road is the most sort of glaring example. If you look at the court file 2895, that's the landscape plan. This is the entirety of what they were proposing to be the screening for 160,000 square feet of waste concrete. 2895. Said that kind of fast. And so in the south, you see there's no screening whatsoever proposed, such that along Airport Road, a public right-of-way, you can see those piles. There's photos in the record that confirm that. But then also in the northeast area of the site, which is where my clients live up in Kellytown, there's a gap for a utility line in their proposed landscaping. So even under their sort of best case scenario, they put in a photo simulation of what this might look like in a generation when the trees grow up. There's still going to be a gap in that landscaping buffer.
So I'm struggling with that because like they, you know, the SIP, let's set what the staff report says aside for a second. Just conceptually, I mean, they have a right of ingress and egress to their property. I'm struggling with understanding how you have like trees that are so dense that you can't see through, but we're going to get like heavy machinery, tractors, concrete, trucks through what?
Well, on an ingress and egress, I think you could have a solid gate. So that's not an insurmountable problem. But the reality here, with what you're struggling
How tall
with,
would a solid gate have to be?
to be 25 feet tall, it would have to be 25 feet tall. But what you're fighting against is the reality of the Douglas County zoning resolution. It's 1416.05 of that resolution that says if the topography of the site makes it impossible to screen outdoor industrial storage is prohibited.
And is that what that earthen brim is related to? That we could have, had it be feasible, the topography would have been feasible because we would have created topography that would have allowed trees to be tall enough, but now that topography is out of the plan, and what we're left with is what? Not sufficient?
147 trees surrounding 32 acres. And so you have a row of trees. Most of them are deciduous, so in the winter they're not going to have any leaf cover. And so we also dispute whether or not this is actually a hedge, which is what is suggested in the DCZR 141601 as potentially being suitable. But to your point, Judge Pawar, in the preliminary staff report, so before this gets up to final review in front of the planning department, there's a suggestion from staff which says you really should consider an earthen berm here. Or alternatively, you could actually dig down at your site such that 25-foot tall stockpiles are below the horizon. Those are their suggestions. Brandon doesn't do anything. They bring out this photo simulation which says, in 30 years there will be some growth of the trees, and that's where they leave it. But the key part, as you've honed in on, is that the photo simulation doesn't say anything about what happens along the south side of the site. And the photo simulation also shows these gaps that we're talking about. Yes, Judge Richard.
They concede that Airport Road's a public right-of-way. They concede that there's no bushes or trees or anything along the south border. Was the expansion of the site in the southerly direction under this SIP at all?
Well, the reality is that it was a complete reconfiguration of what was approved in
Okay.
2018.
Was it any closer to Airport Road than it was before?
I'm not sure if that's actually in the
Okay.
record. You could compare the two.
Finally, council says that from Airport Road, the batch plant is effective as a barrier. And there's no evidence that the piles can be seen from Airport Road. Do you agree with that there's no such evidence? It's in the staff report, actually.
Yeah, I don't agree with that, Your Honor, and I think the best evidence of that, I'm not sure I have the pin site, but if you look at the court file at 2085, there's a number of photos that we introduced to the record, and it's like the fifth or sixth one, so maybe.
And they're visible, those are views from Airport Road.
Correct. There's a photo from Airport Road showing 25-foot tall stockpiles that aren't screened. Yeah, I know it's hard, but I think it does come through in the record. What they've got, and I want to make sure that I'm clear on this, it's a chain link fence, so there's no screening. I guess the site's probably secure, hopefully, but there's no screening, and that's really the issue from that public right of way.
If we were to decide that that's the only flaw in the plan, what happens? Can we send it back for Brandon to fix that part, or for the zoning board to fix that part of the approval? Or do they have to start all over again?
Typically, they would need to start all over because the approval itself was illegal. Now, certainly, they wouldn't have to start from square one. I think they could pick up their application and amend it. But again, when we talk about our injury and our primary concern here, they would have to correct for this issue, whether they're going to put in earthen berms that surround the site or dig down into the ground so that 25-foot tall stockpiles don't go over the fence, or maybe limit themselves to 10-foot tall stockpiles, because that seems to be what they're suggesting they think they can do. But the reality is, when you talk about the injury to these neighbors and to the surrounding community, it's really the unsightliness of these tall stockpiles that have no screening whatsoever. And Douglas County has recognized that injury by putting these screening rules in place. Our issue here is that they can't pick and choose when to apply those rules. The plain meaning of those rules says that if you replace a wall or a fence with a hedge, it has to be adequate. And adequate means that the industrial storage cannot be seen from the public right-of-ways and adjacent areas. It also says that if the topography makes screening impossible, storage is prohibited.
Storage is anywhere on the site, or just from where it's visible?
I think you could read it either way, but here the evidence is undisputed that it's visible from our client's property and other adjacent public right-of-ways, and that's sort of the beginning and the end of the inquiry, I think.
In terms of the standing question, and the language of, I think it's 3602, we asked counsel about the meaning of a budding property owner. Did you agree with his explanation? Is it an applicant and a budding property owner who has to live abut exactly to the SIP, or a person within 1,000 feet? Or is it just abutting the outer boundary of Brandon's property?
I think the only fair reading of that is that abutting means that someone who's adjacent to their neighbor's property. And I think the question was, maybe it was Judge Pawar was saying, like, if you read abutting the way that Brandon is reading it, then the only abutting neighbor is Brandon, because they make up the rest of the northern part of the property. They introduced this concept in the briefing called the SIP use area. SIP, capital U use, capital A area. That's not found anywhere in the Douglas County zoning resolution. And so I think to Judge Poir's point, this would really invite a situation where you could have gamesmanship. You could have an applicant create sort of an island of improvement that says, oh, we have no abutting landowners, so nobody is standing to challenge this. And I'd submit to you that that's not a reasonable application of these rules.
Could there be a situation that's reverse actually with abutting property where, let's say, the abutting property is way up north, so it's not near Airport Road at all, and the boundary or hedge or whatever is sufficient, so they're not seeing anything, or maybe they are seeing some things, but they're still not happy. So they maybe have standing as an abutting property owner under the code, but not necessarily under common law?
Well, I think that gets back to this idea that neighboring landowners have a common law real property interest in their neighbors using their property legally. And so if you have a non-conforming industrial use, which is what this is, which is what it would be if it weren't screened from the south, that is going to create an aesthetic injury. It's also going to create likely a property value injury because the area is more industrialized, more intensively used than would otherwise be allowed under the code. And I see that I'm out of time, but thank you very much.
Thank you, counsel. Mr. Johnson, you have about 50 seconds remaining for a rebuttal.
On Airport Road, the staff report says that the tower conceals it. Opposing counsel says differently. That's a conflict in the evidence. It is not the job of this court to weigh the evidence. If there is any evidence in the record supporting the decision, that is enough to render that decision not arbitrary. Take a look at the Poets case that opposing counsel attached as Appendix B to their brief, decided by this court just in November. And on a question of whether sewer provisions were adequate, this court said, there is some evidence in the record to support the decision. That's the end of the inquiry.
The staff report says the appellants have not provided evidence to demonstrate that the storage will be visible from the adjoining right-of-way. I don't see where it says the batch plant shields it. Can you give us a reference of the page?
Well, I think right above, the storage area is over 700 feet north of the Airport Road right-of-way with an existing concrete batch plant intervening between them.
But it doesn't say that it provides, it shields it from visibility. That's an inference.
I think that's the effect of what it says. And then there's also the standing issue. Plaintiffs don't live to the
Counselor,
south.
thank you for answering the question. Your time is
Thank you.
expired. I appreciate it. Thank you to both counsel for your briefing and your argument. It's been helpful. We will consider the case submitted and will issue an opinion in due course. And for today, that's our only case. And so court will be adjourned and the bailiff may so call. Thank you both.
Thank you.
All rise. The court will be in recess, subject to call.